The starting point really is to consider the provisions of the Insolvency Act itself. Section 127, subsection 1, is the core provision dealing with the avoidance of post-petition dispositions. There are four key aspects to highlight. Firstly, as will be seen from the wording on the slide, Section 127 applies only in compulsory liquidations. Secondly, it applies to dispositions of property. In a moment, I'll turn to consider what exactly that means. Thirdly, it applies to dispositions made after the commencement of the winding up. And again, in a moment, I'll turn to consider precisely what that means. And importantly, fourthly, the effect of Section 127 is that it renders dispositions of property made after the commencement of the winding up void unless the court otherwise orders. And we'll come on in due course to consider, again, precisely what that means in the context of validation orders. In terms of the history of this provision, it is not by any means a new provision. In fact, it can be traced back to Elizabethan times, certainly in the bankruptcy context. And the first corporate equivalent of this provision can be found in the Joint Stock Companies Act of 1856. So a long-standing principle of insolvency law. One thorny issue which arises in the context of the concept of disposition is the question of payments into and out of the company's bank account. And in many cases, this will usually be the type of potential disposition with which a liquidator is concerned and which they want to try and recover. The reason why there are legal complexities around payments of money is that in a legal sense, all a bank account is a relationship of debit and credit between a bank and its customer. When we talk of a payment being made by bank transfer, from a legal perspective, what we're really talking about is there being a reduction in the balance of the paying party's bank account and an equivalent increase in the balance of the receiving party's bank account.